Welcome this afternoon. My name is Philip Shadler. I am the co-chair of the Diversity and Inclusion Action Team of the ADR section of the State Bar of Michigan. This is the IDIET Diversity and Inclusion Action Team contribution to the section's annual meeting. It's my privilege to be the host and moderator of an extraordinary panel of women. With me today is Julie Markgraf, Katie Shelley, and Ashley Jacobson. These three ladies, women, are extraordinarily accomplished and acknowledged experts in the field of disability advocacy and access. Today, let's see, Julie is an attorney and has been involved with a disability advocacy for a number of years. Ashley, also an attorney, also involved with disability advocacy for not as long as Julie, but for for a respectable period of time. Katie works at the Toledo Museum of Art, where she is in charge of the advocacy and access program for patrons of the museum, and worked with another woman that was supposed to have joined us, but for personal reasons wasn't able to. Katie was one of her students. And so their biographies are included in the materials along with their handouts, and we will post those in the chat for you. They include the handbook for Michigan courts on accessibility and accommodation for individuals with disabilities. Let's see. The 8 A's of accessibility. And forgive me just a moment while I fumble through my paperwork. Oh, well. This
Yeah.
after.
Sorry, I'll help you out, Bill. The third document is an EEOC DOJ Q&A document as a resource for folks to understand better about disabilities and accommodations and modifications.
Thank you for pulling my rear out of the fire, Julie. As usual, somebody had to do it. This afternoon, our panel will address 4 questions. Starting with definition of disability and accessibility, then challenges to what ADR professionals see in this context, then describing opportunities that these 3 highly qualified women see for ADR professionals, and giving us some idea of the intersectionality of disability and other protected classifications for other marginalized groups. And so with that, the first question, and I'll direct it to Julie, is can you give us, I mean, it seems as though people have some difficulty or more difficulty than perhaps other contexts defining what is a disability. Can you guys give us some definition for disability and accessibility here?
Thanks, Phil. Yeah, I'll defer to Katie and Ashley on this one for now.
Which one wants to go first? Shall I flip?
I'd be
Ashley, do you
happy
wanna
to
go
jump
first?
in.
Yeah.
Okay, thank you for having me here today. I really appreciate everyone's interest in this topic. It's near and dear to my heart, as well as my clients. I live as a proud physically disabled attorney, as well as some of the other roles that Phil kind of briefly touched on that I do. Disability is incredibly broad, and the disability community is very diverse. And so for a really long time, people would think of disability as a non-disabled person as someone who uses a wheelchair. And usually the picture that came to their mind is, a middle-aged white male in a wheelchair, because for a very long time in the media, that's what was presented as kind of the complete picture of disability. But what we know working in this field and working with the disability community, and for some of us being part of that community, that disability looks different on everyone. And so when we look at the legal context for what makes a disability, you're going to be looking at whether or not one or more major life functions is impaired or significantly impaired. And that could be vision related, hearing, chronic illness, any type of developmental disability. And so very often in the legal field, we think of disability in the context of disability benefits. But in reality, what we're seeing is that a lot of our clients, whether we are working in the ADR space or in the courts, there's a need for a better understanding about the diversity in that disability community, because people with the same disability could look entirely different depending on the day. Also, under the law, if you have a record of having a disability, that can make you fall under disability rights laws. A good example of this, for anyone who was watching the Paralympics recently, there were people with disabilities that to others, their disability may not be readily apparent, but they had previously survived cancer, and that treatment left them with some lingering disability symptoms, even though they were in remission. So even if you don't have a current diagnosis, if you're regarded as having a disability, meaning you're treated as having a disability by others, or you have a record of having a disability, that can fall under the legal definition. But the crux of this presentation today in this panel is that while we know disability looks different for everyone, the statistics are clear that the legal profession and our society as a whole are dealing with increases in diagnosis. So we're seeing a lot more clients come in with varying disabilities, and we want to make sure everyone is prepared for that. But we also want to make sure that we're taking a very individualized approach, because the 1 in 4 US adults that has some kind of disability may present differently, and they all have very diverse legal needs, not just with disability benefits, estate planning and long-term care planning, employment cases, special education cases, and even in areas like family law. And so I think that's probably a little bit more than what you were looking for there, Phil, for an answer, but I think that's a good place to start.
Haiti, is there anything that you'd like to add to Ashley's definition?
Yeah, that was a great place to start. And also, as a woman with a physical disability, I never thought that disability would be something that would influence my career path. It's something I've had my entire life, but I really didn't intend to build my career around it. But what I learned in starting to work in the disability advocacy field was I was thinking about accessibility and disability in a very narrow sense. As a woman who is a wheelchair user, I was thinking about how places could be accessible for wheelchair users. But now I work at an art museum, and one of the first challenges I was tasked with when I started working here was how we can make our art more accessible to individuals who are blind or have low vision. So thinking about there's so many different facets of not only disability, but types of accessibility as well. And I did just want to highlight, there's what we call in the disability studies community, the social model of disability and the medical model of disability. So the medical model of disability focuses on the diagnosis. You have a medical diagnosis of a disability, and also that disability is something that is medically wrong or different about a person, and that we should try to fix that. We should try to fix the disability and fix the person. The social model of disability kind of flips that on its head and says that it's society that needs to be fixed. and we need to fix the infrastructures and the buildings that are inaccessible, or the lack of accommodations for an individual with a disability, are what truly makes a person disabled. They are not able to have equitable access to the same goods and services that their peers who at this point in time don't have a disability. They can't access those, therefore society renders them disabled. And that's the social model of disability. But disability is also the only minority population that anyone can enter at any time. And so I think it is really important to note that even if you don't have any personal experience with disability now, that is more than likely not going to be the case 5 years from now, whether it's yourself, whether it's someone close to you, whether it's a client. Disability, as Ashley mentioned, 1 in 4 individuals in the United States have a disability of some sort. And it's very likely that you will be impacted by disability in some way throughout your life, whether it's aging or otherwise.
Thank you, Katie. So Julie, that's a great segue. I think we've been reminded that we will be impacted. We will encounter people with disabilities. 1 in 4 adults in the United States suffers from some sort of disability. What challenges, given that, what challenges do you see for ADR professionals?
I think one of the biggest challenges, there are really two, and they both revolve around lack of understanding about what disability and accessibility is and isn't, which Ashley and Katie just did an excellent job of giving an overview on, and then lack of understanding of the law and why the law is the way it is. And, Ashley emphasized the individualistic nature of disability. One person can have different needs on different days. And that's true with all of us, right? Whether you have a disability or not. Some days you may be more tired for whatever reason, because you didn't get enough sleep, because you have a disability. And so that can impact what your needs are for that day to effectively function. So the individualistic approach and thought process is very important for people in understanding how we make sure that we have more accessibility. So, the understanding that the law applies to mediators and arbitrators as places of public accommodation, the definitional area that we fall into under the ADA, which is Title III, and understanding that the two main components of the ADA, and I say ADA, we use ADA because it's the federal law, but state laws very closely follow it. So it's not just the ADA, obviously, but the two main components are, number one, you can't discriminate based on disability because of what Ashley said. Everybody's an individual, everybody's different. If you have 5 people with the same diagnosis, they may all have 5 different needs. So you can't make assumptions based on diagnosis, and you can't discriminate based on diagnosis. So you can't screen out based on diagnosis when you're looking at mediation, other types of ADR. And then the second thing is the need to provide modifications to the process so that everybody has equal access and is able to participate and appreciate, the reasons that they're there in this process. As far as the first prong of can't discriminate, shouldn't be screening out, I think the easiest thing to keep in mind obviously I encourage everybody to study case law and get fully informed and look at the resources that we've provided, because there's all kinds of great detail out there, and every day, every year, there's more and more resources out there. So it makes it much easier to understand and really make this a part of your day-to-day practice so that it's not a big, big issue, a big deal. But to boil it down, as far as not discriminating, the number one thing is look at behavior, not diagnosis. All right. And I'll give you some examples of that. So we talked about individuality and the reason to not look at diagnosis, but the ADA and similar disability laws don't necessarily give people a sword that allows them to have behavior that would otherwise be inappropriate. For example, if somebody's intoxicated at a mediation session or an arbitration, they're stumbling, they're knocking things down, they're bumping into people, that behavior is not appropriate for the setting, and it's not going to be conducive to an efficient process. That person can't say, well, I'm alcoholic, so you have to put up with this behavior. It's a separate issue. It doesn't matter whether you have that diagnosis or not. The behavior is not appropriate, so we're going to address it as appropriate. It's a safety issue, it's a distraction, whatever the case may be. So we can look at that behavior and address that behavior. Another example is if somebody's being belligerent or threatening, that behavior is not appropriate. And the person can't say, you know, they can't use the ADA as a sword and say, well, I have a personality disorder or I have a brain tumor, so you have to put up with me being belligerent or threatening because that's what's causing this behavior. That's not acceptable either. We're not going to discriminate against somebody when we hear or suspect that they have a personality disorder or a brain tumor, but we're also not going to ignore behavior that isn't appropriate for the setting. A third example is if someone's not responding meaningfully, you know, you're having discussions during a mediation session and their answers are inappropriate or non-existent or very short, and you get the sense that you're not really connecting. It doesn't matter whether they have a diagnosis of cognitive impairment or Alzheimer's. What matters is there's a disconnect in communication. And so that's what we want to look at. And that's what we want to address. So that brings us to the next half of the ADA, which is the need to make modifications. So when you have somebody, for example, who doesn't seem to be responding meaningfully, you want to look at what modifications can we make to this process to make it effective for everyone. And whether it's that behavior or any other behavior, or whether it's something that someone says they need as a modification, as an assistance to help them participate in the process, that's what we want to focus on. And the key part about the modification half is focusing on dialogue and not assumptions. So again, the reason that we focus on behaviors and not diagnosis is that we don't want to stereotype, we don't want to make prejudicial decisions. Similarly, with the modification process, we want to focus on, tell me what this means for you. Tell me what you need to make this process effective for you, as opposed to, oh, you have that diagnosis? Well, I know just what to do. I'm going to do X, Y, and Z. We don't want to go there. I see a hand up, but I don't see who has it up.
And we can't see who the,
So if somebody who has their hand up,
Julie,
Julie, it looks
it's
like you
you.
do. Yeah.
I
I think,
Julie, that's your hand.
I think, Julie, I think when you
Because I-
raise your hand, it does it automatically.
I talk with my hands, I'm sorry. Okay, and we do have some questions in the chat, so let me look at these real quick. Okay, I'm just going to go ahead and read here because it's a long one. Given I just left a session where a presenter wanted to go back to in-person for mediation and motions, I don't think people take into account how different disabilities show up, with one being unable to attend court in person due to mobility conditions, financial issues, unseen mental mobility conditions like depression. All of that should be taken into account when advocating for inclusion. Absolutely, that is a perfect post-COVID example of an accommodation. And we're going to talk a little bit more about those types of things in a few minutes. So hang on and we'll get back to that issue. And then Zena says, but what if someone is stumbling around because they have Parkinson's? Wouldn't we need to accommodate under that situation? Yes, absolutely. And the whole thing with the behavior is, how is this behavior affecting the process? So if it's something that we can address with a modification with auxiliary aids and services, whatever the case may be, changing location, doing Zoom instead of in person. If we can accommodate it, if we can make modifications to the process to make it better for everybody, then of course we're going to do that. If it's something that is behavior that we can't in any way effectively address with a modification or an accommodation, then that's a different issue. And that may be a situation where we say this isn't going to be an effective process because of this behavior. So it really just depends on the behavior and how it affects the process. So that's, that's the first step. And then the second is let's try our darndest to find a modification or accommodation that will work for everybody. None of that gets to the point of, well, if you have Parkinson's, then we have to do this or that. So the diagnosis doesn't matter. The behavior is what matters. The needs of the person are what matters. Does that answer your question, Zena?
Sort of. It's a long conversation, but the person who is intoxicated and is stumbling, that's such an interesting example.
Mhm.
Because maybe there are modifications that could be made for that person, but don't we need to know the diagnosis? I mean, that's, to me, that's the question, is if somebody is saying they're intoxicated versus they have Parkinson's, doesn't that knowledge make a difference in whether or how we can make accommodations? And so in some situations, isn't it
can't.
really helpful to know the diagnosis?
I would say the key is if I see somebody stumbling, I'm going to be thinking to myself, what's going on here? This isn't typical behavior in a mediation. Is this person intoxicated? Do they have a cognitive impairment, Parkinson's, anything else? Did they just miss lunch? And so, they're a little out of it. So yes, all of that is true. But the key for me as a mediator is I'm not going to make assumptions and ask them, are you drunk? Do you have Parkinson's? I'm going to ask them, what's going on here? This doesn't seem safe. Let's talk about this. And if they say, I have Parkinson's, yep, XYZ, this is what's going on, then we can talk about what we need to do. Katie, Ashley, do you have other thoughts about that?
Yeah, I just want to add that in the vast majority of circumstances, people with disabilities are able to participate in mediation and ADR without raising those very valid red flags that Julie raised as an example there. When I'm working with a new client or doing an event, one of the first things that I ask on my client information or intake sheets is, we want to make sure that the materials we give to you and the process is accessible to anyone with disabilities. If you feel comfortable disclosing that now or at any time, please don't hesitate to do so, and we can handle it in a confidential manner where appropriate. And typically that opens the door to like kind of an honest discussion about, well, I might have trouble with mediation in the early morning because I take my morning medication and it makes me drowsy for a couple of hours. Or if you see me stumbling around, like Zena, and I forget who else asked that question. I love that question because I myself live with tremors. And so I always, when I first started practicing law, I would always tell people, I'm not nervous, I'm just shaky. And so I think as people with disabilities, we're very used to explaining and at times over explaining what's going on with us in our bodies. And so I like that Julie's input is that we want to be respectful of when and how a person discloses a disability while focusing on the individual. And if there are ways to accommodate or modify the process, whether it's larger font or remote signing options or remote mediation options, which I'm a very big proponent of doing things remote because the pandemic taught us that we can be efficient and great at our jobs in accessible ways like that. So I always encourage that discussion in the beginning, and also keep in mind, sometimes you hear from other parties on the case about the other party's disability, and that's not always accurate. So you want to make sure that you're leaving the space to have that honest conversation in private as well as when appropriate with the group.
Yes, yeah. And I want to echo what Ashley said about having a standard question as an intake about you sort of explain the process, right? You give them an overview of what to expect, and then asking every single participant, how does that sound to you? Does that make sense? Do you think that's going to be effective for you? Very open-ended, not, do you have a disability I need to accommodate? Because you know what? Somebody may not want to tell you. Like Ashley said, a lot of people are very comfortable talking about their disability and their needs. Other people may have a disability that they want to keep hidden, that they don't want to talk about, and that's fine. So as long as you're asking an open-ended question that applies to everybody all the time, which I think we're all pretty much doing in some way, shape, or form anyway, making sure that you have those avenues available for people to speak up as much or as little as they feel comfortable, and then addressing all of them on an individual basis, saying, thank you for letting me know. Let's talk about how we can modify the process. Let's make sure we put in place what we need to put in place to make this work for you.
Thank you. So helpful. Thank you.
Katie,
Okay.
do you want to elaborate a little bit?
No, because I think everything that I was going to say was said by Ashley, so I'm all set. But
Well, then
There's
that,
another,
go
I'm
ahead.
sorry, Bill. There's one other question that I'm not sure we directly, I think we addressed most of them, but there's one here that says, if someone is intoxicated, doesn't that go to whether they are even able to comprehend and understand the process? Yes, probably, right? I mean, if somebody has one drink at lunch and that's a standard practice for them, and so, it doesn't affect their cognitive ability and they're able to fully participate, then, probably not. But if in my example of somebody being so intoxicated that they're stumbling around and bumping into people, number one, that's safety for the other people. Number two, they may not be able to comprehend and fully participate on a cognitive basis. So it may be appropriate to say, look, we need to take a break here, we need to reschedule, whatever the case may be. And so my point is that we're not going to say, oh, you're an alcoholic, well, then you can't mediate, right? That doesn't make any sense at all. Because as long as the person is sober and able to participate, of course they can participate. It doesn't matter that they have that diagnosis.
Well,
So
isn't it, I'm sorry, isn't it true that in some cases, a medication regimen will mirror alcohol intoxication? People can appear to be drunk when in fact they're simply grappling with the effects of their meds, and that, does that change the response to that
I hope
situation?
I start to sound like a broken record. I'm not going to ask them about their medication in detail, right? If they say, hey, I'm taking some medication that causes me to be a little off balance, but otherwise I'm fine, let me just get seated and we'll be fine to go. I'm not going to ask them, what medication are you taking? What's your diagnosis?
Oh.
I'm just going to say, okay. So it's all about the behavior and what's going on and what the needs are of the parties. It has nothing to do with diagnosis.
But that, not going into that in-depth inquiry kind of goes to this question about competency or capacity to participate. How do you,
Again, you don't have to ask about diagnosis to do that. You don't have to ask if there's a disability causing it. It's, I'm sensing that your responses, you're taking a while to respond when I ask you a question, and your responses are kind of short and one-word answers. You're focusing on the behavior. Let's talk about this a little bit more. If the person has an attorney, then they may be able to add information. But you just kind of, I want to make sure that you're getting the most out of this process. So let's talk about what's going on, and I want to make sure you're understanding. So let me try to restate some things and have more of a conversation with you to make sure that you're understanding what's going on here. And again, if they volunteer, yes, I have a cognitive condition that's impacting this. It impacts my speech, but not my cognition. Or maybe they don't say anything at all about any, medical issue or disability. Just I'm a little tired today, or I'm overwhelmed by this process, but I'm good to go. You know what I mean? So you just have that open conversation with them, share with them what you're seeing and what your concerns are about the process and about their effective participation in it. Katie, Ashley, do you have any other suggestions on that.
And well, kind of along those lines, I saw the question from Gary about mediation being held in the attorney's office. In that instance where the restrooms were in the basement and there weren't any elevators. It made me chuckle a little bit because that's something that I've dealt with personally when I'm working on cases in certain attorneys' offices, as well as some courthouses still in the state of Michigan. And so how I've personally dealt with it, not to say that there aren't other ways of handling it, but when I know as a disabled lawyer that I am going to be participating in mediation or facilitating it, or my client has a disability, I always reach out to the mediator at least a week, if not more, in advance, and just state, we're aware that there may be some accessibility or accommodation needs for the mediation. I want to make sure that those are handled to give everyone peace of mind ahead of time. Can you give me a little bit of information about is the doorway accessible? Is there a push button? Where are the restrooms located? And that's not to say that you can be told everything is great and accessible, but show up on the day and it's not. I've dealt with that as well. And I think that's where education through panels like this one and some of the resources that Julie and Phil and Katie pointed out are great steps for that. But as disabled people, we realize that due to kind of usually these unnecessary barriers in our legal system, we have to kind of over prepare. And I also think because of a lot of our lived experiences, it's understandable that people with disabilities might be hesitant to share about them having a disability. When it comes to the disability community, they're 2 to 3 times more likely to be victims or survivors of violent crime. That number is even higher for economic crime, of course, higher for employment discrimination cases. And they've gone through usually several attempts to try to get people to understand where they're coming from, but they face these either physical or other barriers when they participate in the process. So I think being patient with the people that you're with to disclose in whatever way they feel comfortable, and really always bringing it back to the individual's needs for that process. If they don't know how to accommodate the process because they're not mediators, a great resource that I always point out is the Job Accommodations Network, askjan.org, where it's by environment, by job, by role, it gives suggestions about accommodations and things like that. But also there may be just universal things that we can all do to make the process more accessible. Not only asking up front if there's any accessibility or accommodation needs, but just leaving that space for the person to respond and communicate in the way that works best for them. But usually with a little bit of pre-planning, we're able to address disability. And then I found once you get into the habit of doing it, it really is second nature. You'll pick up on it more and more as long as you're giving the opportunity to the clients to participate in the way that they need to.
Katie?
Again, I think I don't have anything else to add, but I just, and that this is my ignorance of perhaps from coming, from a different background, but would lawyers' offices or attorneys' offices be places of public accommodation? So shouldn't
Yes.
those be accessible under the Americans with Disabilities Act already? I mean, I know very well that there are still many places out there that are not accessible, but in an ideal world, all places of public accommodation should be accessible for all people with disabilities.
Yeah.
It actually touched a nerve for me, and I think it's appropriate at this point. She talked about pre-planning. And it occurs to me, Katie, that you have large groups of people that come to the museum.
Mhm.
Those groups of people include people with disabilities, and you must have some mechanism for identifying those issues and anticipating them and being able to accommodate. How do you do that?
Well, so one of the ways I attempt to do that. So my position, I was hired by the Toledo Museum of Art 3 years ago. This is the first position of its kind here, but it was to look at the barriers, both physical barriers and programmatic barriers at the Toledo Museum of Art, and come up with a plan for removing those barriers and making sure that the Toledo Museum of Art, as a place of public accommodation, was truly accessible to everyone. So looking at our restrooms, making sure all of our restrooms were accessible to wheelchair users. Do we have the Braille labels on all of our restrooms, on our elevator? Is our elevator accessible? We just remodeled our elevator. It hadn't been updated since the 1970s. So, things like that, coming up with a plan for removing barriers, and then that way, and also educating the people I work with on what we have available, so that when visitors do reach out or try to pre-plan, we have the information available that we can give to them. But my hope is eventually that we won't have any barriers. That is the goal. I don't know if we'll ever get there, but I would like us to get closer, that anyone can come through the doors of the Toledo Museum of Art and have an enjoyable experience and not have to worry about, is this place going to be a welcoming environment for me and my body?
Yeah, absolutely. And then Gary had a follow-up comment about the mediation that took place in an attorney's office where the restrooms were in the basement with no elevator. He says, we didn't know in advance. It wasn't a case where we had pre-mediation conferences. I think as a mediator, I think it's appropriate for us to make sure that we do have those pre-planning conferences. And if it's a facility that's going to be used that we're not familiar with, we should make sure that we understand what that location looks like. And if it's not ADA accessible, then talk about whether or not we need to have a different location. So, I think it's perfectly appropriate. And again, Phil, I'm sorry, I'm going to jump the gun here because I hate doing challenges first and not opportunities. I want to get to opportunities. I don't want to run out of time. The opportunity here is we as mediators are focused on how can we help these parties reach an agreement that's going to be meaningful for them. If somebody can't fully participate in mediation, they're not going to be able to benefit from it, right? It's such a core belief for a mediator to make sure that we're doing everything we can to make this effective for people. So as a mediator, make sure that you're doing that work up front. I want to share with you guys just a couple of examples. These are examples. I want to give a shout out to Dale Ann Iverson, Ann Bockley Pfeiffer, and Bob Wright, who do tremendous training for mediators, including wonderful information about accommodations. And these are some of the specific examples that Dale has shared in her training in the past. I want to share them with you because these are examples of how we are already all doing this all the time without even realizing it. So it's not a huge leap. It's not like making things accessible is a huge shift for us, right? We're already doing it. So, for example, raise your hand if you've ever heard something along the lines of I'm concerned my client can't be in the same room with the other side. All right. That may be because of a disability or not. It doesn't matter. What matters is we need to know that to make the process effective, right? I'm concerned my client will need breaks. Doesn't matter why they need breaks, because they're overwhelmed, because they need to take their medication, because it takes them time to process. What matters is they need breaks. And yeah, you may get into the details of how many breaks and why and all that, but the diagnosis doesn't matter, and we're already doing this anyway. Are you going to make me stay in this mediation for a long time? How long is this going to take? I don't know if I can do a whole day of this, right? Regardless of whether it's because of disability or not. People may need to select a different location. We need to be thinking about that proactively in advance and making sure we address that. They may need a service animal. So we need to make sure that we think about that and accommodate that if that comes up. Okay, I'll get off my soapbox, but
Well-
my main point is, yeah, don't look at it as a huge issue because it's core to us to do this.
I want to make sure that we addressed Flora's question. Flora, can we hear from you? Can we give voice to Flora Cabin?
Accessibility suggestions for virtual and remote mediations. Yeah, I think I read that one earlier on. If somebody can unmute Flora, that would be the best.
Hey, I'm unmuted now. Thank you.
Okay.
I know you guys were focusing on, the physical accommodations, but I think there's also probably some issues we need to address when we work primarily remotely or virtually. And I was wondering if you can kind of provide at least what are some minimal accommodations we should consider, whether we ask whether a client needs them or not, or participants needs them or not, but what are some things we should be thinking about in the remote world to make sure folks are accommodated?
Okay, well,
Yeah.
that ties in with our last two questions, and I'm kindly reminded that we're running out of time, which I think is a tribute to the interest in this subject matter, because this has been a very lively discussion. But the last two questions are, what opportunities do you see for ADR professionals? And we've kind of been talking about that. And can you folks give us some ideas of this intersectionality of disability and other protected classes or other marginalized groups? Help us understand. We've talked about the fact that 1 in 4 adults has some sort of disability. Where does this take us as ADR professionals?
Yeah, to talk to both that and Flora's question, I would say, again, we want to focus on the individual. So we want to make sure that we're asking those open-ended questions during intake and throughout the process as appropriate to make sure that we are checking in with folks and asking, how are you doing? Is this working for you? Do you have any questions? Do you have any concerns? Do you have any needs that aren't being met through this process? Tell me what you're thinking and feeling, and if you need anything. So that should be happening at intake and then as appropriate throughout the mediation arbitration. As far as specifics for Zoom accessibility, I think that Zoom has a lot of that information on their website. And there are some, the SCAO ADA document that I shared the link for in chat has some information on that as well. So those are always good things to kind of, research and get up to speed on, but don't let that cause you to make assumptions about someone. Still ask an individual what they need instead of assuming what you think they might need.
And if I could just jump in really quick too, that 8 A's of accessibility document gives kind of a framework that you can adapt to based on your business needs, but I don't want it to get lost in all of this, that while the law does require you to make sure people's disability rights are upheld and not violated, serving people with disabilities is really good business. I think oftentimes people that work in our fields forget that. They assume based on stigma or just lack of experience, personal experience with disability, that there's not good money in working with people with disabilities. I can tell you, having worked at other law firms before starting my own practice, that there's a lot of money to be made in serving the disability community, and members of that community come from all backgrounds, all races, ethnicities, sexual orientations. And so I love the question about intersectionality too, because very often one of the barriers to getting people to buy into mediation is whether they feel like they're actually going to be heard and understood, or, well, why even try because we've gotten nowhere thus far. But when you really look at who is handling start to finish the cases as they come in, how they're handling it, and doing almost like an after action assessment in your mind. Okay, what did we find accessibility wise? that didn't work this time that maybe we could propose to people in the future to address that. But again, there's so many people with disabilities that reach out to me, or that I'm trying to find mediators to work with on those cases or to refer people to. And unfortunately, until recently, there wasn't a lot of interest in this topic. So I really appreciate everyone caring about this. But also financially, it's smart to care about this too.
Any other questions for our panel members?
I just wanted to chime in, and I can't remember if it was Julie or Ashley who said this, but going back to the intersectionality piece, it's not just the straight white male in a wheelchair when you're thinking of disability. Obviously, as disability itself is multifaceted, so are the identities of people with disabilities. And so there are going to be people of disabilities who are part of other marginalized communities, whether they're women, whether they're people of color, whether they are immigrants. There are so many factors that can make a person's identity, disability just being one of those. And I think that's important to remember as well when going through the mediation process.
Well, folks, my greatest fear has come true. I felt when we embarked on this adventure that we would give these remarkable women 40 minutes to talk about something that we could quite easily have spent a whole day discussing. And thank you to our audience for having helped us expand our vision of that. And perhaps what will happen next is that we'll take the opportunity to have a more in-depth look at disability and the opportunities in the ADR profession for accommodating disabilities and making ourselves more accessible to those who have disabilities. Julie, Katie, Ashley, Mary Ann for sure. Thank you for all of the hard work that you did, and I appreciate it, and I know that the Disability and Inclusion Action Team appreciates that. You were outstanding, and I think we've flat out run out of time. But as I said, I'm encouraged because we had a great turnout, and I think we've opened the door to a much broader conversation.